Okay, so I can see we are already online. So I guess the time has come for us to open our meeting. So good evening, everybody. My name is Vlad Bondrovsky. I'm working with Sayenko Harenko, and I'm also the deputy head of the International Law Committee at the Ukrainian Bar Association. And I'm highly honored to open this meeting today, as this is our first meeting of this section. So why are we here today? Because the Russian-Ukraine war has been lasting since 2014. After February 2022, there is hardly anybody who hadn't faced the consequences of this war. Therefore, our committee also decided to address the issues, and we started a series of webinars that you are welcome to participate. And these webinars, we will address and analyze available mechanisms of protecting investments, analyze differences in protecting regimes and available mechanisms, and also voice our recommendations and preliminary solutions. Let's maybe rush to our speakers today, because we have a rather diversified panel with speakers from different jurisdictions and different backgrounds. Our first duo to speak today is Olga Kuchmienko and Viktor Pasechnik. Olga will deliver on how means of investment protection and mechanisms of compensation may differ in different territories of Ukraine. Viktor, at the same time, will help with examples of the Ukrainian business and foreign investors suffering damages due to the war. So I guess, Ola, the floor is yours.
Thank you, Vladislav. Thanks everyone for joining us today at our webinar, and for everyone who will listen to us in recording. Basically, today we want to start our series of webinars for about international law for in-house lawyers. And we want to speak about how to protect Ukrainian and foreign investors from the consequences of Russian aggression in Ukraine. And today's chapter is devoted to the European Court of Human Rights. Together with Viktor Pasechnik presentation, we want to cover the topic on how the means of investment protection and mechanisms of compensation may differ on different parts of Ukrainian territory, depending on what basically is what has happened there. Before we even start to talk about it, so just before I proceed, do you see my presentation or not?
Yes, it's visible.
Okay then.
No, I can't see a presentation at this moment.
Maybe Victor, then maybe you can open this presentation on your computer separately, because if it is, can other speakers in the chat write whether they can see it? Yeah, Lauren.
I think we can see the presentation in the stream, so I guess most of the people should see the presentation.
Yeah, okay, then Victor, if you may just open this presentation from your email, I think you have it. So basically, why do we speak about this topic? We will speak also about key facts, how these key facts can be relevant for the businesses, can the territory matter, and Victor will help us with examples of the Ukrainian business and foreign investors suffering damages, and we will speak about available protection measures. So basically, why we want to speak about it. International Law Committee wants to help business with a better understanding how to get compensated for damages caused by Russian war in Ukraine. And secondly, we want to show how this will help in understanding on how to build a robust claim file for force majeure notices towards your customers or business partners. Key facts, just for everyone to know, that Ukraine remains in its border since 1991. Regardless Russian aggression that has started in 2014, with annexation of Crimea and hostile measures in Donetsk and Lugansk regions in eastern part of Ukraine, nothing has changed on international law level. That means that Ukraine, from international law perspective, remains in its borders. But finally, in 2022, unfortunately, in February, the full-scale war has started. And moreover, it started with Russian agreements with Lugansk and Donetsk, so-called states that are, of course, illegal. And after full-scale war started, the entire Ukraine has been affected. Important that additionally to these factual events, there were also legislative acts in Russia that were passed in relation to these territories. It has happened in 2014 when the Crimea was accepted as a subject of federation to Russian Federation. That meant basically the start of effective control. And also in September 2022, Russia has started a process of accepting some newly occupied territories of Ukraine. In particular, it was cities and regions of Kherson and Zaporizhia. Also, here I have a screenshot from Russian website with legislation, and only in October, so basically a couple of days after the start of this process, already 1, 2, 3, 4, 5, 6, 7 acts were available on the Kherson topic. For example, one of them is a signed decree by Putin on transferring ownership of the Zaporizhia, Ukrainian, nuclear power plant to Russia. So these facts are given here just to show you that International Law Committee follows these topics and that they are very important for international law assessment of these events. But how these key facts can be relevant for businesses? These facts are important because they help to define a more specific cause of damage by Russia of the property and investments in the territory of Ukraine. In other words, we can identify which actions Russia committed in that territory and how to attribute it to Russia. So, for example, what we are talking about, was there any boots on the ground situation? Was there a missile attack or effective control? Why this is important to identify what has happened? Because it helps to evaluate and qualify the actions of Russia and its army in different parts of Ukrainian territory from international standpoint. In other words, which legal concept to apply to particular action. Why legal concepts are important? Because it helps to define and choose the best property or investment protection mechanisms, including damages compensation in the territory of Ukraine, for businesses and individuals that suffered from Russian aggression. In other words, entire logic of this chain goes to the fact to which institution it is better to go to protect your interest and how to prove the fact that it has happened. In order to prove, you have to build a strong claim file. But why we are talking also about the territory? Because why cannot we speak about just territory of Ukraine? It is important because Russia has committed different illegal actions in different parts of territories, starting from 2014, but mostly we are speaking about the period from February 2022. So, for example, if we speak about main situations that happened in Ukrainian territory, we will speak about Crimea, for example. In 2014, effective control started in Crimea. It was Russian effective control. It happened even before Crimea was accepted as subject of Russian Federation. But then in eastern Ukraine, even before 2022, international armed conflict has happened, and it was admitted by preliminary statement of ICC. Then from 2022, temporary physical presence of Russian army has happened in different parts of Ukraine, and it created physical damages to the private property and infrastructure. It has happened even in Kiev region, with different examples. Then in Western Ukraine, where luckily Russian forces were not there, there were no boots on the ground there, but there were missile attacks in Western Ukraine, included in infrastructure and civil objects in Lviv region, in Vinnytsia, etc. Then we go south, Kherson and Zaporizhia. I just showed you that, first of all, they might have been occupied from international standpoint, but also can we speak about effective control over the territories given the pieces of legislation, of course illegal ones, in Russia in terms of Ukrainian territories. Then we can speak about Mariupol. Everyone has heard about Azovstal. We can speak about Kharkiv region that is under massive missile attacks, and where the Russian army actually had presence there. And here we speak only about legal concepts that concern businesses. We even don't speak about war crimes, etc. And our member of the committee, Viktor Pasechnik, will present a couple of examples of the Ukrainian businesses and foreign investors that has suffered already damages due to the Russian war in Ukraine. We are not speaking about any applications to European Court of Human Rights yet. We are speaking only about examples of damages. And Victor will help us to understand how differentiated these events in different territories, even to different businesses. Victor, the floor is yours for the next couple of minutes.
Thank you, Olga, for providing me such an exciting opportunity, and I'm glad to see you all. So let's start. The first company with which I began my research is Cargill. I think all of you know this company. It's one of the world's largest agricultural producers and traders, and one of the largest privately held corporations. Cargill lost its sunflower crushing plant located in Kherson. It was taken by the Russian occupants during the very first days of the war, and it was one of the key assets of Cargill in Ukraine. Moving to the next company, it's Coca-Cola. Coca-Cola suffered damages due to the damage caused to its production facility near Kiev in Velika Dimerka town. During the first days of the war, there were heavy combat involving the heavy armor, and the production facility, including the power plant, was damaged. And after suffering this damage, Coca-Cola also could not restore access to its plant due to the demining, which lasted for about 1 month. Olga, can I please have a next slide?
I have switched already.
Okay, maybe I have some problems. So next company is UBA International. It's one of the world leading FMCG companies. It suffered significant losses according to the company's financial statement. These losses amounted to $143 million US. The company suffered damages to 2 production facilities in Vyshgorod and Trostianets. These facilities were damaged during the hostilities. The Russian occupiers destroyed the company's plant in Trostianets, and the company also reported that this facility was robbed by Russian occupiers fleeing Trostianets after the combat. And moving to the next company, I want to tell you about Danone. Danone lost one of its key production facilities in Ukraine, in Kherson region, also during the very first days of the war. This production facility was significantly damaged, and the company lost the control and still can't access its plant. Also, Danone reported that its warehouse near Kyiv was damaged by the Russian missile strike. Moving to the next examples, a recent example is Mariupol. It's Azovstal and Ilyich metal and steel work plants. They have filed a claim to the European Court of Human Rights, and Akhmetov, Ukrainian oligarch, in his interviews stated that 16 of his companies has already filed or will file such claims because they lost metal and steel works in warehouses located on territory of these two plants and located in Mariupol port, and vessels that have been already loaded and subsequently seized by the Russian Federation. And the last example is Ukr Farming. It's a really large agricultural company owned by Ukrainian oligarch Bakhmatyuk. Recently, he gave an interview with Forbes in which he stated that his company lost about 160 hectares of land and suffered damage of about $1 billion. The most important part of this damage is a poultry farm in Chernobyevka in Kherson region, which was destroyed, and all poultry located in this farm was killed. Also, there were losses on other territories. For example, production facilities in Mykolaiv and Kyiv were damaged due to the missile strikes, and the company was forced to stop its production facilities in Bakhmut and in Donetsk region due to the danger of shelling and occupation. So I'll pass the floor to my colleagues, and they will continue with more detailed information about the European Court of Human Rights and its role in protecting investors' interests.
Thank you very much, Victor. Just why we have provided you with these examples. It's just a few examples on main publicly available information, and we wanted to show how the territory can matter for the legal case file for each of these examples. So what is common? All these companies have faced damage to the property and investments, but what is different? The type of action and maybe legal nature of the action that was committed by Russia, by Russian army in Ukraine. For example, if there were no boots on the ground, physical presence of Russian army in certain part of territory, the investor can have still a chance to claim damages from Russia. So even if it was a missile attack in Vinnytsia, that is still possible to claim these damages. Also, it is important to base and to ground its claim on a proper legal nature of the Russian action, what it was: effective control, hostilities, occupation, other damages. For example, there were damages in Lviv and Crimea, as you can see, but there were no missile attacks in Crimea from Russia. So basically, damages were present, but not the missile attacks. But there were no. On the other hand, there were no physical presence of Russian army in Lviv, but damage was still there. So basically, understanding of like how to put in which words put the actual factual effect will help to define the legal mechanism that is the most suitable in your case to get compensation, or maybe you can have several of them. And today's webinar is a first in series of webinars about available protection mechanisms. Today we will talk about the European Court of Human Rights, but we will talk the next months hopefully about litigation and enforcement abroad. We will talk about court claims against Russia in Ukraine and abroad. We will talk about enforcement of the Ukrainian court decisions abroad. We will talk later in 2 months about investment arbitration. We will talk even in 3 months about public international law mechanisms like reparations, administrative commissions, etc. Why we do these webinars? We want to help companies in finding out which compensation measures are the most efficient in different cases. And secondly, we want to help the companies to understand how to build their robust claim file towards their partners as well. So for example, if something happened and you want to speak about force majeure, you cannot just say that, okay, it's just Russian war in Ukraine. You need to build facts. And this understanding will help you to build this factual and legal background of your letters. And today we have several speakers that will help us to understand the nature of the European Court of Human Rights claims. Unfortunately, one of speakers, Emily, got sick and she lost her voice, so she cannot join us today, but we still hope to have Emily in our following webinars. And that is why the floor is open for everyone to ask your questions in the chat and to follow us during our events.
Let me briefly intervene here, Ola. So we already have several questions in the chat, and some are coming to my direct messages. But let's keep them for the Q&A section, and then, although the one question that I think you could address right now. So a person asks whether we are aware of any investment disputes that have been already initiated, and whether there was any difference made regarding the territories. So would you like to take that question?
I think that investment disputes will be discussed in our following webinars. I would like to focus on a European Court of Human Rights today, because we have our esteemed speakers about this topic. But I am sure that our investment cases on Crimea can be used as good examples and good practice for other territories as well. But so far, publicly, I haven't seen anything that we can discuss during European Court of Human Rights topic and investment topics, because today we are talking about applications to the European Court of Human Rights, and there are some of them.
So just a brief comment from me as well. I'm not familiar with any. I'm not aware of any investment disputes that has been commenced after the reinvasion in 2022. So I guess we're still waiting for that. And that's why basically today we're speaking about the more urgent matter, the European Court of Human Rights. And that's why I'm rushing to our next duo of speakers. We also have today Alexei Koltok, who will present on the applications to the European Court of Human Rights. He is a counsel with Seyenko Harenko. And the second speaker is Tony Nagolitsa, who is one of our dearest friends, because he has been providing immense help for our research and our work throughout these troubling times of war. So I will first provide the floor to Alexei.
Yeah, thank you, Vladislav, for having me here. It's nice to hear you. So I'll try to cover in my speech the procedural aspects of filing application to the ECHR. And now I'll try to share with my presentation. Do you see it? Yeah.
Yes.
Okay, thanks. So when the war has started, we all, as lawyers, start thinking about how to collect damages from Russian Federation. And actually, we thought that it will be quite easier task for us, and we will probably have this mechanism. But later we understood that international law is not as much regulated as like national law, and it becomes much more complicated to understand that finally you will receive result and you will collect this money from Russian Federation. And one of mechanisms which we discussed with our colleagues was application, a direct application to the ECHR. And so, as you know, Russia is ceased to be a member of the convention, starting from the 16th September of this year. However, it doesn't mean that Russia will not responsible for the damages which it caused to individuals or to the state. And therefore, it will all the cases which have been filed before this date, and for the missions of the convention guaranteed rights will be considered by the court, and the decision will be taken. In general, picture for the ECHR looks the following. At the date when Russia ceased to be a member of the convention, there was about 17,000 applications which was initiated against the Russia. About 8,500 was filed due to the military conflict in Ukraine, as of the date when the Ukraine filed the interstate claim to the Russian Federation. About 11 applications was filed since by Ukrainians since 2014, when first of Ukrainian territory was occupied. As you know, from the publicly available information, about 5 only big companies or group of companies have been applied to ECHR. Such groups as SKM, Rinat Akhmetov, Metinvest, who filed a group application with 16 companies. Public Broadcasting, it's a national television company, Ukrhydroenergo, and a lot of others which are not so public and popular as this one. As we are talking about the amounts of just satisfaction which was awarded in the during the 10 years from 2011 and 2021, you see that Russia is one of the most I would say, the countries who own a lot of compensation to the applicants, but the hugest amount in this scope belongs to Yuka's case, and others is for different complaints. But that's actually doesn't matter at this moment, because we know that Russian Federation adopted a law by which it will not enforce or execute the decisions which was adopted by the ECHR after 16 March 2022, because it ceased to be a member of the Russia of the Council of Europe. So it was, as you remember, a period of uncertainty when we all know that Russia applied to the Council of Europe and with its application and tried and requested to cease its membership in this organization. And the Committee of Ministers adopted its resolution and decided that Russian Federation ceased to be a member of the Council of Europe as from 16 March. And it was like a victory from the Ukrainian side, but as lawyers, we understand that it was quite uncertain for us, because as we know that according to the Article 58 of the for Convention of for the Protection of Human Rights, any high contracting party which shall cease to be a member of Council of Europe shall cease to be a party to this convention under the same conditions. So we considered whether the Russian Federation ceased to be a member by 16 March or it will have some additional period of time. And European Court of Human Rights announced its press release that all cases which was initiated before this were suspended. It was about 2 weeks of uncertainty, and on 22 of March this year, European Court of Human Rights adopted its resolution and informed that the Russian Federation ceased to be a high contracting party to the conventions on 16 September 2022. And the court remains competent to deal with application directed against the Russian Federation in relation to acts or omissions capable of conclusion or violation of the convention, provided that they occurred until 16 September 2022. It means that we still have a chance to apply to the ECHR with our applications, and what is even in these days, because we have we have 4 months to submit our applications after the 15th of September of this date. What we have other picture in the ECHR, we have several state complaints in the interstate application, which was already considered by the European Court of Human Rights. Here is some available information on this. You can follow the link. It will be attached to this presentation, and we have several cases with respect to Crimea and Eastern Ukraine. We have other cases. I will not pay attention to them because there is no, not to waste our time. And the most important what we are discussing today is the application number 10, Ukraine versus Russia 10, which was filed due to military conflict in 2022. It is a new application which was filed to ECHR by the government of Ukraine on 23 of June. And this application is related to unlawfully due to a military attack of Ukrainian territories by Russian Federation. As you see from the press release which was announced by European Court of Human Rights, these applications relates also to the thousands of corporate entities have had their businesses and property destroyed. So in this application, we understand that the Ukrainian government will will provide the information that not only individuals or the state have suffered from this Russian invasion, but also businesses have suffered from this war. And Article 1 of Protocol number 1 of the Convention is also subject for the consideration under this interstate complaint. We know that a lot of other countries have been applied as third parties to this process, to this interstate application. There were 23 countries which have already filed these applications. Ireland and United Kingdom have requested the additional term to apply with their application, and the court will consider this case, their application, in a due course. So you see that all international community, I would say, stay for Ukraine and will support our application as well. As we discussed before with the Ministry of Justice, with the Commissioner of Ukraine in the UCHR, most probably that all individual applications will be suspended until the interstate application would be resolved by the court. So let us follow to the individual applications and what we have to pay attention to when we considering about whether apply to ECHR or not. First of all, we need to understand that there are two admissibility criteria for ECHR to start to commence the proceeding in the court. First of all, in general picture, situation looks like that. You have to follow all the measures at the national level, and you have to submit your application within 4 months, starting from the date when your right was violated. However, due to we have a military conflict, and we understand that there are no effective measures to defend our right at the national level in Ukraine or in Russia Federation, because we all understand that all other attempts to file a claim within the national legal system in Russia Federation will be I would say will not provide us with the result which we want to achieve. And at the national level in Ukraine, you also cannot receive satisfaction of your rights because of different the law of international private law provides for the state immunity, and the second one, even if you breach this immunity and our legal system provides you with a right entitled you with a practically way to receive court decision, you understand that this decision most probably would not be enforced in Ukraine, because there is no assets of Russian Federation, and as well as due to nationalization laws from Ukraine, it will not be enforced in Russian Federation because of the political issue, and it will not be enforced in foreign countries because of immunity of Russian Federation. And this allows us to conclude that we can apply directly to ECHR and to seek for compensation and to award to us a just satisfaction. What about 4 months? As you know, that in general, 4 months starting its begins starting from the final decision of the national court, the last instance. But as we have not, as we do not apply to the national court, this term starts from the date of violation, or starting from the date when we understand that our right is violated. So we can, to conclude, we can apply directly to ECHR with our application within 4 months, starting from the date when our right was violated. What is the second we need to understand when we apply into ECHR? We understand that there were a preliminary practice of in military conflicts, and the most important case, besides Yugoslavia, I would pay attention to Georgia against Russia, the second case, where the court decided that you can claim for compensation, or you can apply to ECHR only with that demands when in case the respondent state violated your rights on the territory when it exercised the effective control. And that was important practice which was not broken at this moment. And therefore, it is quite strange and probably illogical that Russian Federation initiated a lot of missile attacks, which broken the territory, all the territory of Ukraine, Western Ukraine, Central Ukraine, etc. And it quite logical that Russian Federation is not responsible for this missile attacks. And what we understand that this problem is very huge, and we understand that our Ministry of Justice, who initiate interstate claim, they do believe that this approach will be changed, and probably the ECHR will conclude that Russia is responsible for the damages which it provides within even in that territories which Russia does not exercise as the effective control. However, we all understand that such risk is still present because of previous practice of this court. What about the procedure of considering the complaint? As you know that in to file every claim in all jurisdiction, you have to demonstrate that you have a title on the property, it was destroyed, there is a the connection between damages and the activity which was provided for these damages, and you need to have a calculation for which show that this amount of damages is in the relevant amount. But applying to ECHR, you need first of all provide information that you have suffered from the action from the respondent state. And in your initial application, you have not to you should not provide exact calculation of the damages. You need only to provide an application form which is published on the website of ECHR, and then and provide evidences that this property is belong to you, and provide information that it is broken, and this evidence should be sufficient to consider that this application is admissible to be with the ECHR. Also, you have demonstrate that there is no means, as we discussed earlier, that there is no means for protection of your right at the national level, and you filing this application within 4 months period since the violation occurred. After that, the court will receive your application and provide you with information that hopefully your application is registered and there is a number of this application. After that, this application will be notified to the respondent state, and then each party will be entitled with the right to submit the evidence and its written observation. Only at that time you will have to submit your claims for just satisfaction, and after this the court may appoint hearings. They can be oral or written, and then the court will make a judgment in this case. Separately, the court may appoint another hearing to consider the ruling on just satisfaction, but it will be separately only in that case, in case the decision for just satisfaction will not be ready when the court making a judgment. As you see that the claim could be considered by a single judge, committee, chamber, etc. So what is the main point in this situation? That ECHR could satisfy your claims with just satisfaction for pecuniary damages and moral damages. It could satisfy your application with direct damages and lost profit. So the main principle is that you should be renew in your rights in such situation that like you like omission of your rights, it was not actually taken. However, the ECHR is not obliged to award to you all damages. Probably in some situation the court may decide that only a decision when your right was when the court make a judgment, it's by itself provides you with the satisfaction of your rights. However, the main principle is that all damages should be compensated by respondent state.
Thank you, Alexei. Thank you very much.
You.
That was very insightful, and we will surely revert to your presentation during the Q&A section. And now we will pass the floor to Tony with his speech. Thank you, Tony.
Thank you, Vlad, Olga, Victor, and Alexei, to everyone. And of course, thanks to the UBA for organizing this webinar series and everything you're doing. I'm very happy to be here. So following in Alexei's steps, actually, I just wanted to speak today to focus on an interesting case that arose from the ex-Yugoslav experience at the ECHR, with the hope that some takeaways would be interesting and prove useful to current considerations of in-house counsel in the Ukraine. And to conclude, I'll try to highlight some pros and cons, humbly, that I believe that separate DCHR as a mechanism of investment protection, to try and elucidate the similarities and differences between different methods of investment protection. So very briefly, as Alexei mentioned, so investment protection at the ECHR is typically understood to fall under Article 1 of Protocol 1 and the Convention's guarantee of peaceful enjoyment of possessions. in conjunction, of course, with other guarantees from the convention as necessary. And of course, the case law that has developed is markedly different from how it is understood in the investment arbitration arena, or of course as well as national laws. And then the one case that I thought could be interesting was a case that occurred after the breakup of Yugoslavia, where even outside the damages that were suffered from military interventions, plenty of businesses have found themselves in new jurisdictional landscapes and with difficulties providing effective means of asserting their claims. And one of the most interesting cases here was the case of the Slovenian Ljubljana Bank, Ljubljanska banka. It concerned a bank that was administered under a socialist Yugoslavian model of self-governance, which is a topic in itself, but fascinating nonetheless. And before the breakup of Yugoslavia and before the war, it had clients all across the federal Yugoslav states. And of course, after Slovenian independence, the bank was subsequently nationalized, and several multi-directional issues popped up. So after the nationalization, the bank was unable to effectively collect any claims that it had towards the rest of the ex-Yugoslav territory, while at the same time its former clients and creditors had no access to their funds and savings and in general their claims. So what that inspired was a bundle of applications, both Article 33 and 34, before the ECHR and other bodies. It was a geopolitical hot token in negotiations of Croatia's accession to the EU, and they fruited some valuable takeaways as they concern the protection of property at the ECHR. So the cases were four of them, at least grouped into groups of four. First, by the creditors of the bank and the clients of the bank. This was Kovacic et al. V Slovenia and Alešić et al. Versus the former Yugoslav republics of Bosnia and Herzegovina, Croatia, Serbia, Slovenia, and Fyrom, or what is today known as North Macedonia. So these first cases ended by rulings by the ECHR that Slovenia and Serbia have violated Article 1 of Protocol 1 and the convention by not allowing their former clients access to their savings deposited with Ljubljanska banka. This was obviously followed by the instruction of the court that this be remedied as soon as possible within a year. Following that, Ljubljanska banka fired back against Croatia, which was ultimately found inadmissible at the ECHR. So this was Article 34, an individual application. After this, Slovenia initiated Article 33, so interstate application against Croatia, alleging damages of 500 million euros plus interests for 25 years back of interests. And both cases were struck out as inadmissible, at the latest of which in December 2020, so less than 2 years ago, and almost 30 years after the end of the war. But the cases are often cited in case law of the ECHR because of the reflections made by the Grand Chamber and as they regard admissibility requirements and the requirements regarding peaceful enjoyment of possessions, and of course other adjacent claims. So as Alexei mentioned, in an ECHR, admissibility is as important as the merits, arguably even more so than in other mechanisms of investment protection. One curious item in passing was in the Ljubljanska banka cases, there was a big finding of what constitutes a victim or victim status under the convention, where it was said that the key criteria in establishing whether a state was responsible for debts were whether or not there was a company's legal status, so was it under public or private law, the nature of the company's activity, whether it's a public function or an ordinary commercial business, the context of operations, monopolies and heavily regulated businesses, and the key finding of institutional and operational independence. So because such high claims were declared inadmissible against Croatia, it only goes to show how important considerations of admissibility are when making Article 34 applications. One other thing that was very interesting in these cases was the findings of the ECHR as they regard proportionality and positive obligations of the state to ensure peaceful enjoyment of possessions. As regards proportionality, the ECHR stuck a test that's similar to other public international law tests of fair balance, stating that the interference with the right of peaceful enjoyment of possessions must take into account the demands of general interest and the right to regulate, as it's called in the investment arena, I guess, and the requirements of the protection of individual fundamental rights. It went further to establish that in the context of Article 1, Protocol number 1, positive obligations may require the state to take measures to protect the right, the individual's right to property. So this is actually was sort of an upgrade of the negative requirement prescribed in Article 1, Protocol 1, saying that everyone has the right to peaceful enjoyment of possessions, right? So the default would be that no one can interfere with those rights. So some interesting findings about positive obligations there as well. And this maybe sort of to circle back into the general topic of the webinar as to how the ECHR fares and as with in comparison with other investment protection mechanisms. I would stress that some of the pros or the advantages of individual applications are that, like Alexei mentioned, like that are there sort of, for lack of a better word, they're affordable and accessible. The initial application to be made is really needs to be straight to the point and without burdening the sort of the admissibility section with more than prima facie evidence of violations. There is, and what's off-cited as the most the biggest advantage of the ECHR's individual application mechanism is the lack of a nationality requirement. So if whereas investment cases, as we've had questions from the audience already, would require nationalities, whether they be dual or singular, but the ECHR, the convention, provides for everyone found in the territory, and as well as also developing on the investment comparison, interference in the peaceful possession of property at the ECHR may be deemed as unlawful even without complete destruction or complete expropriation or whatever. So those are some of the pros, whereas the cons would be what I also believe there was a question from the audience, of course, the requirement to exhaust local remedies. And we've already established, Alexei has pointed out that this requirement is waived if there is if it's considered that this would be a disproportional obstacle to the effective exercise of these rights. But also the short deadline. So the 4 months after the violation has taken place is if it hasn't expired already, it is coming up very quickly. And also the overwhelming backlog of cases at the ECHR. The numbers are just staggering, and there's a lot of the applications maybe do not get a full regard as they deserve. This is, of course, like I mentioned, the Ljubljana bank cases ended less than 2 years ago, and this was a factual matrix that occurred beginning of the 90s. So that's something that plenty of of people would find too long and burdensome. And also just to touch upon the restitutio in integrum that Oleksiy mentioned as well, is the habit, the practice of the ECHR to award substantially lower amounts than investment cases. This is, of course, this isn't necessarily a bad thing. This is something that is in line with, I think, sort of the compensation as it is understood in several legal systems around the world, markedly not common law systems that often feature very inflated claims, but the compensation also goes to costs as well. So perhaps that's a consideration to take into account. I'm mindful of the time, which I'm sorry if I was speeding through things a little bit, but I believe that covers the sort of points I wanted to raise. So of course, thank you very much again for having me here, and yielding the floor back to Vlad.
Thank you, Tony. Thank you. I guess your speech has made our audience to ask a couple of questions that I think were addressed to you mainly, and well, this also enlightens us on the interest that our audience has to investment disputes, which we will be addressing in the next webinar that we invite you to join. But still, right now, the question to Tony is whether he thinks that the investment arbitration could be more efficient than the European Court of Human Rights mechanism, and what was the Yugoslavia's experience, maybe in terms of number of cases or the outcomes of the court cases.
Well, of course, what is efficient and inefficient entirely depends on what your needs are. I think is the safe answer. But the ex-Yugoslav experience with investment claims has had a very long outreach, because of facts that occurred during the war or immediately following the Yugoslav wars. They have sort of lingered in the legal system without actually sort of affecting any one investment individually and deliberately, but they still feature in one way or another the remnants of the old system, and possibly the effects from the war are still present in almost, I mean, to my knowledge. They feature very prominently in a lot of cases at some point in one or another. So maybe to answer your question more succinctly, I mean, to say that efficient redress is the objective, I would say that there is a higher likelihood that lodging an application at the ECHR will be a good way to go at this juncture. There's also one I mean, I'm not an expert on this topic, but the parallel proceedings between investment arbitrations and the ECHR are a thing, and it's obviously depends on there's also a res judicata or lis pendens principle with the ECHR, but that's a bigger can of worms to open up right now. It's definitely something to consider. If I were a business looking to protect my investment, I would definitely look into both options with equal care.
Thank you. And just to close all the section with investment related investment disputes related questions, there was also this question whether the standard for compensation is the same on the investment disputes, investment arbitrations, and the ECHR. So I think I could cover this very quickly. It depends on the specific violation that the investor is claiming that has taken place, because in that case, sometimes based on the Cherusa factory case, the compensation would be based on the complete reimbursement like we have in the ECHR. With at the same time, when we are talking about other violations, the specific type of compensation could be different, and it also depends on the applicable VAT and etc. So that I guess covers the investment questions. So please, our audience, stay tuned and come to our next seminar. I can see that you are very eager to participate. And we also have this question from the chat from Dmitro Donenko that I feel was not really addressed So I guess maybe Alexei could answer that. And the question is, are you aware, Alexei, of any compulsory enforcement mechanisms for European Court of Human Rights decisions?
Actually not. We understand the situation is, looks like that, when the ECHR takes its decision and awarded just satisfaction, it is addressed to the respondent state, who shall enforce it by its own. And we see only a way for enforcement, not enforcement, but by voluntary execution of its decision, when Russia Federation, by the pressure of international community or society, will return to the Council of Europe and shall enforce or shall pay the just satisfaction under the old decision which will be already taken against Russia Federation. And we see example in the history. It was Cyprus, as far I understand, as far as I remember, situation when there was sorry, it was Greece. Yeah, when Greece ceased to be a member of the convention, and then returns in 2 years to the convention was applied again, and Greece have to pay all the compensation which was awarded by ECHR.
Plus, I believe there is always a possibility that after victory, the power in Russia will change, and they might be more
I
ready
believe it will
to
be before our victory. Yes.
Okay, dear colleagues. Then this is. There is another question from Dmitry Donenko. I guess that's a follow-up. So, what do you think about initiating recognition and enforcement mechanism in a similar way as for a foreign court decision? So I guess that's once again for you, Alexei.
Actually, we are not aware that in some countries such mechanism was applied. As you know, for example, I don't know whether Dmitry is from Ukraine. I'll put it as example. You know that Ukraine have some budget line in our budget when for enforcement or for paying compensation under the decision of ECHR. I believe that such a mechanism in each country who is a member of the Council of Europe, and therefore we do not believe that probably in some states there is such mechanism, but I'm not aware about this. I don't think that the decision of ECHR could be subject for enforcement proceeding on the national level of each country. Because, as you know, it is prescribed for by convention that Committee of Ministers is entitled to control over enforcement of the decision of ECHR, and it is provided by negotiations with each country who is the respondent state.
Yeah, thank you very much, Alexei. So I see no more follow-up questions. So I will right now close our webinar for today. First of all, thank you very much to all our speakers. We are very much welcoming you to our next events as well. Then I would also like to let everybody know that we are open to questions in case you have them later, so you can send them via our email. At the same time, you could also let us know if you would like to contribute to our next events or even speak at those panels. We are, just to give you some taste of what we are planning for you for the next events, we have decided that the next month, we will talk about litigation and enforcement of decisions abroad. Then we will talk about investment arbitrations, And the last webinar in this section would be dedicated to private international law mechanisms. Public international law mechanisms. So could reparations or administrative commissions and such like bodies be effective in case of Russian-Ukraine war? So at this, I think we can close, and I will be very much happy to see everybody next time. Bye-bye.
Thank you.
Thank you, everyone.
Thank you.
Thank you, everyone.
Goodbye.
Join us during next events. Bye.
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 Bye.